You know that whole CSI effect you see on TV, right? A crime happens, some brilliant scientist in a glowing, high-tech lab runs a swab, the computer beeps, flashes a giant green match, and bam, the case is instantly closed. It makes for incredible television. But if you're a practitioner or a law student here, you already know it paints a highly distorted picture of how justice actually operates on the ground. Welcome to this explainer for Pakistan Legal Insight. Today, we're cutting right through the Hollywood smoke and mirrors. We're going to dive into the rigorous and honestly often unforgiving reality of expert evidence in Pakistani criminal trials. We're going to explore exactly how forensic science is treated under our law and why the courtroom is a far more demanding environment than any television laboratory could ever be.
So let me pose a scenario to you right out of the gate. Let's say you have flawless forensic evidence. Does that automatically guarantee a conviction in a Pakistani court? If a highly qualified expert takes the stand, looks the judge in the eye, and points the finger at an accused, are the judge's hands tied? You might assume that science always has the final word. But as we're going to see today, under Pakistani law, the court, not the scientist, is the ultimate arbiter of truth. The judge doesn't just blindly accept a scientific conclusion, they dissect it.
Here's our roadmap for this explainer. First, we'll cover the core legal principle. Second, medical evidence versus eyewitnesses. Third, ballistics and chain of custody. Fourth, the DNA Act of 2020. Fifth, handwriting and document forgery. And finally, the ultimate evidentiary verdict.
Section 1. The core legal principle. Let's get right into the foundational law that governs everything we're about to discuss.
Before we talk about DNA swabs or bullet trajectories, we have to understand the law that actually opens the courtroom doors to these scientists in the first place. And that brings us to the absolute bedrock of our discussion, Article 59 of the Qanun-e-Shahadat Order 1984. This law states that when the court has to form an opinion upon a point of foreign law, or of science or art, or as to the identity of handwriting or finger impressions, the opinions upon that point of persons who are specially skilled in those areas are considered relevant facts. The law explicitly calls these specially skilled persons experts. So think of Article 59 as the legal VIP pass. It identifies the exact, specific categories where expert evidence is legally relevant and admissible in a trial.
Now, in criminal proceedings, you're going to encounter a pretty vast variety of these experts. Let's quickly outline the 5 most common types you'll see on the stand. First, medical officers or doctors. They give evidence on critical things like the cause of death or the specific nature of injuries. Second, we have chemical examiners. They analyze the chemical composition of substances. This is absolutely huge in narcotics cases, but also essential for identifying poisons or explosive residues. Third, ballistic experts. They examine firearms, ammunition, bullet trajectories, and firing ranges. Fourth, handwriting experts, who are also known as document examiners. They determine if a disputed signature is genuine or if it's a forgery. And finally, a rapidly growing field, digital forensics experts. They handle the extraction, authentication, and analysis of data from mobile phones, computers, and other electronic devices.
But here is where we hit the golden rule of this entire explainer. It's beautifully illustrated by a landmark case, Mian Ghulam Rabbani v. the State, cited as PLD 2007 SC 234. In this case, the Supreme Court of Pakistan laid down a principle you must absolutely never forget. The court held that the opinion of an expert witness is not binding on the court. It is simply one piece of evidence that must be assessed alongside all the other evidence in the trial. Listen, a judge is never obliged to accept an expert's opinion merely because that expert has a fancy degree or even if their opinion somehow went unchallenged by the defense. The court is actively required to assess the expert's reasoning, their methodology, and the factual basis of their opinion. If an expert's opinion is poorly reasoned, if it's based on an inadequate examination, or if it outright contradicts other established facts in the case, the court has the full authority to reject it completely.
Section 2. Medical evidence versus eyewitnesses. This is a clash you will see in virtually every single Sessions Court murder trial.
In these violent crime trials, you're going to encounter 2 very critical medical documents, and you need to understand the stark difference between them. On one side of the aisle, you have the Postmortem report, or PMR. This is the doctor's report on the examination of a deceased body. It states the exact cause of death, describes the injuries in detail, and estimates the time of death. It's produced as a primary prosecution exhibit. On the other side, you have the Medico-Legal Certificate, or MLC. This is the report on an injured, living person. It describes the nature of their injuries, notes whether those injuries are fresh or healed, suggests the probable weapon used, and states whether the victim is medically fit to make a statement to the police. Now, when a medical officer takes the stand, defense lawyers will ruthlessly cross-examine them on these exact documents. They are hunting for inconsistencies. Does the doctor's estimated time of death in the PMR actually match the prosecution's timeline? Are the injuries described in the MLC truly consistent with the weapon the prosecution claims was used? Or, and this is a big one, are there defensive injuries on the accused, suggesting they were actually attacked first?
This brings us to a really fascinating legal clash, resolved perfectly in Sultan Mehmood v. the State 2014 SCMR 1567. What actually happens when the doctor's objective report completely contradicts what the eyewitnesses claim they saw? The Supreme Court held that where medical evidence is inconsistent with the prosecution's ocular, meaning eyewitness account, the scientific evidence takes precedence. Think about it. If the doctor's postmortem evidence proves the deceased was shot from a distance of at least 50 feet, but the prosecution's eyewitnesses swear the accused was standing directly beside the victim point blank, you have a massive, stark contradiction. The court ruled that this kind of inconsistency creates a serious doubt about the prosecution's version of events. Because medical evidence is objective and scientific, it has to be favored over interested eyewitness testimony when they clash. And in our justice system, that resulting doubt must be resolved in favor of the accused.
Section 3. Ballistics and Chain of Custody. Let's shift gears to firearms offenses and the biggest procedural hurdle prosecutors face. The ballistic expert's job is to examine the recovered firearm, the spent cartridge cases from the scene, and the bullets recovered from the victim's body. Now, if they can match a bullet from the deceased directly to the specific firearm recovered from the accused, that is devastatingly powerful direct evidence. But, and this is a massive but, matching a bullet to a gun means absolutely nothing if the state cannot prove the chain of custody. The chain of custody is the procedural hurdle of properly collecting, properly sealing, and securely forwarding these exhibits to the forensic science laboratory. Every single person who handled that evidence, from the crime scene to the lab bench, must be documented meticulously. This flawlessly illustrates the principle laid out in Ditta v. the State, 2011, PCR LJ 234. The Lahore High Court held that if the prosecution wants to rely on ballistic evidence to link the accused to a crime, they must establish the chain of custody beyond any shadow of a doubt. If there is even a minor break in that chain, for instance, if the firearm or cartridges weren't properly sealed in a parcel at the scene, or if the wax seal was found tampered with or broken when it arrived at the laboratory, it raises a fatal question for the prosecution. How can the court be absolutely sure that the exhibits examined by the expert are the exact same exhibits recovered from the crime scene? They can't. Therefore, the court ruled that an unbroken chain of custody is an absolute evidentiary prerequisite. Without it, the ballistic evidence completely loses its significant weight. Section 4. The DNA Act of 2020. This is the most modern, scientifically complex area of our discussion today. Before this landmarked act, DNA in Pakistani courts was handled on a somewhat ad hoc basis, without truly standardized procedures. The DNA Federal Act 2020 finally brought the necessary regulatory oversight. Let's walk through this statutory framework, because it's vital you know this. First, it established the National DNA Database, which is a centralized repository maintained by the Forensic DNA Analysis Center. Then, it laid down very strict operational rules. Section 8 makes DNA collection mandatory for accused persons charged with specified serious offenses. We're talking about murder, rape, and terrorism. Section 13 provides the legal legitimacy, stating explicitly that DNA evidence shall be admissible in all criminal proceedings, provided the court assesses its reliability and, of course, the chain of custody. And Section 14 ensures quality control. It requires that DNA evidence must be given by a qualified DNA analyst who followed prescribed, recognized laboratory procedures. Now, because DNA is so incredibly sensitive to contamination, the chain of custody requirements are incredibly rigid. For DNA evidence to be given full weight in court, there is a strict 6-step checklist that must be satisfied. Let's go through them. 1. The biological sample must be collected by a qualified person using sterile equipment. 2. It must immediately sealed in a prescribed container with all the requisite markings. 3. The sealed sample must be forwarded to the lab through a fully documented chain of custody. 4. The laboratory itself must maintain a meticulous internal record of every single technician or person who handled it. 5. The DNA analyst's certificate must specify their exact methodology and officially confirm they complied with all procedures. And 6. Any break in the chain must be explained. Let me warn you right now, an unexplained break at any step creates a fatal doubt about the integrity of that DNA sample, rendering it legally useless. So, assuming everything was done perfectly, how do the courts interpret a valid DNA match? In Zulfiqar v. the State, 2021, PCR LJ 789, the Lahore High Court applied the new DNA Act to a rape case.
They held that if biological material from the scene matches the accused and the chain of custody is flawless, it is direct evidence of the accused's presence at the scene. When corroborated by other evidence, it absolutely can sustain a conviction. However, the court issued a massive note of caution that you must remember. DNA establishes biological presence. It does not necessarily prove a criminal act. Think about it. The fact that your DNA is in a room just proves you were in that room at some point. It doesn't prove you committed the murder that happened in that room. Therefore, it must always be assessed alongside all the other corroborating evidence.
Section 5. Handwriting and document forgery. Let's transition to a totally different discipline, heavily used in fraud and check cases.
Under Article 59, handwriting evidence is highly relevant, but you have to be very cautious here. Document examination is not as mathematically precise as DNA analysis. A handwriting expert compares a disputed signature on a contract or a check with admitted specimen samples, which are known verified samples of the suspect's writing. Because of this, handwriting evidence is probabilistic, not absolute. Even if an expert confidently says a signature is consistent with or probably written by the accused, that statement alone does not constitute proof beyond a reasonable doubt. Furthermore, the expert's entire opinion is entirely dependent on the quality of those comparison specimens. If the known samples are poorly chosen, if they are insufficient in number, or if they're compromised, the resulting opinion is totally unreliable. And today, these experts also face the massive hurdle of computer-generated and digitally altered documents, which often requires digital forensics teams to step in and help unravel. This inherent limitation is legally cemented in Muhammad Aslam v. The State, 2016 PCR LJ 234. The Lahore High Court made it crystal clear that a handwriting expert's opinion is relevant, yes, but it is never conclusive on its own. If the prosecution's entire case for forgery rests solely on an expert who just stands up in court and says, yes, the signature matches the accused, well, that is legally insufficient. The court ruled that a bare opinion without detailed reasoning is of limited evidential value. To actually sustain a conviction, the expert must painstakingly explain their methodology to the judge, showing exactly how and why they arrived at their conclusion, pointing out the loops, the strokes, and the pen pressure.
Section 6. The ultimate evidentiary verdict. Let's bring all these distinct categories together for our final practical takeaway. We've looked at medical doctors, ballistics experts, DNA analysts, and document examiners. If we pull all this together, what is the core lesson here? The common thread running through Pakistani criminal law is this: science never dictates the verdict automatically. The evidentiary weight of any expert relies entirely on two fundamental pillars: sound methodology and a bulletproof chain of custody. Whether it is a broken seal on a ballistics exhibit under the Ditta principle or a bare, unexplained opinion from a handwriting expert under the Muhammad Aslam principle, strict procedural compliance is just as important as the science itself. No expert opinion binds the court automatically. At the end of the day, the judge remains the ultimate gatekeeper of the truth.
So I'll leave you with this thought. If science isn't binding, how will you scrutinize the next piece of expert evidence you encounter in your practice or your legal studies? Will you just look at the flashy conclusion? Or will you dig deep into the methodology and the chain of custody? It's a critical lens you absolutely must apply to every single case. Thank you for joining me for this explainer. If you found this breakdown valuable, please make sure to like, subscribe, and follow Pakistan Legal Insight for more deep dives into the realities of Pakistani law. We'll see you in the next one.